Hey there, I'm estate planning attorney Paul Rabelais, and in this video I'll discuss the potential conflict that a person has when they're creating their durable power of attorney, particularly when they're in their second or third marriage and they have adult children from a prior marriage or relationship. So pretty much everyone who gets their estate legal affairs in order creates a power of attorney. Some people call it a durable power of attorney or general power of attorney or financial power of attorney. For now, I'll just refer to it as a power of attorney. And yes, most people also, regarding your future healthcare decisions, will also create, depending on their state, a healthcare power of attorney or advanced healthcare directive or healthcare proxy. But those healthcare appointments are a video for another day. In this video, we're talking about your money and not your medical treatment. So people create these powers of attorney because if you don't, and if you get to a point during your lifetime where you can't, due to your illness or injury, sign your name, deal with your money and financial accounts, pay your bills, and you haven't created a power of attorney appointing someone to act for you, then people will have to sue you in a court guardianship proceeding in order to have a judge declare you legally incompetent and to have a judge appoint someone, whoever the judge thinks is most fit, to make all your future decisions about your money and your life. These guardianship proceedings need to be avoided at all costs. They're expensive with legal fees and court expenses. They take forever to go through the court process, and they put the control of your money and your estate in the hands of a judge. So one step in avoiding this potential guardianship proceeding in the future is to create a power of attorney. With your power of attorney, you get to designate who will have the authority to manage your money and property in the future when you can't do it yourself. This person is often referred to as your agent or your attorney in fact. I'll refer to them as your agent. And designating someone as your agent on your power of attorney can be a powerful and important designation. For example, if you have a $3 million IRA in your name and you get to a point where you don't have the capacity to deal with your own affairs, the agent that you designated will bring your power of attorney document to the financial institution and then have access to your IRA. Now, sure, power of attorney rules do not permit your agent to remove your money from your accounts and spend it all on themselves. Your agent does have a duty of loyalty and care to act in your best interest. But you should by now be getting the picture that you better designate the right person. So if you're married to a responsible spouse that you love and you have responsible adult children from a previous marriage or relationship, you might be torn between who you should designate as your agent on your financial power of attorney. Remember, this person will handle all your money if you get to a point where you're alive and you can't handle it yourself. It's possible that if you appoint your spouse, your children might get nervous that their step-parent will abuse their position as the agent on your power of attorney, remove money from your accounts, and then spend it or pass it along to your spouse's children. If you designate your adult child as your agent, your spouse may get worried that you and your spouse won't get the funds needed during your lifetime to provide for you and your spouse in the same standard of living that you had before you became incapacitated. So what do you do? Well, ultimately, it's your decision. Here's what I find. If you and your spouse got married later in life and you each have your own kids, your own assets, and each have an estate plan where each spouse is leaving their estate or the bulk of it to their own children, that person is likely to designate one of their responsible adult children as their power of attorney agent. However, if you're leaving the bulk of your estate to or for your potential future surviving spouse, then we tend to see those people often designate their spouse as their power of attorney agent. And while you are permitted to designate two or more people who must work together as co-agents on a power of attorney, designating co-agents can often lead to disputes between the two or more people who are listed as co-agents, particularly if they don't agree on how your money should be used during the time you are alive but incapacitated. But please don't make your power of attorney designation based on the way I've seen many people attempt to do it. I've heard many a person say something like, "You know, Paul, I feel bad. I designated my spouse and two of my responsible kids to handle certain roles like executor, trustee of my trust, and agent on my healthcare directive. But poor little Johnny, I haven't designated him to handle any role, and I don't want him to feel left out. I realize little Johnny's been in and out of rehab several times now, but I feel like he should have some role in my estate. So let's designate little Johnny as the agent on my financial power of attorney. That is the wrong way to look at it. It may turn out that the agent you name on your financial or general power of attorney may wind up having more power than any other designation you make. Really, the sole basis for determining who should be your agent on your power of attorney should be something like, if I get to a point during my lifetime when I can't handle my money, who do I trust the most to handle my money? Who is most capable of making my financial decisions in my best interest? Who is organized and articulate and has an excellent relationship with the other participants and family members and heirs of my estate, along with a willingness to perform these tasks without expecting compensation or anything in return. That's how you should look at it, regardless of how others may think about the decision that you make. So if you feel you need to get your estate legal affairs in order, you can click the link in the description below and request a no-expense Zoom estate planning design meeting with me, where we'll explore what you want to accomplish from an estate planning perspective and figure out the most efficient way to accomplish it through my national estate planning law firm, America's Estate Planning Lawyers. Now go ahead and have a great day.